All right. Okay, everyone. So when Travis comes in, I'm gonna go like this, and you guys, please clap when he comes in. There he is. Woo! All right, that's it. Panel's over.
That was the intended response. Thank you very much.
All right. Hi, everyone. Thank you for joining us. We're going to spend a little bit of time talking about video games and technology policy and law. I'm Luis Zambrano Ramos. On my day job, I am an attorney and policy advisor, but I'm here purely in my own capacity.
And I am Travis Hall. I am, in my day job, the Director for State Engagement for the Center for Democracy and Technology, and I was actually Luis's colleague at the Department of Commerce for the last 10 years.
Well, he was my boss.
Which is why he was so nice in letting me come a little bit late.
Yeah. Okay, so what is technology policy and law? So it's a very broad concept, but by policy, we generally refer to the preferences about the state of things. And law in this context is a key way to achieve certain policies. These choices come with trade-offs, different benefits accrue to different people and groups. And by technology policy and law, we want to explore the structures and systems in place that affect the ability of people to develop and access technologies and communicate and share with one another. There's lots of subjects: privacy, copyright, cybersecurity, trade, many players, governments, players within governments, advocacy groups, companies in different industries, lobbyists, and everyone here. Unless we say something otherwise, we will focus on the US, but there is a bigger international dimension here.
Yeah, why don't we go ahead and go, we're going to talk about a little bit, right? This is a little bit about what is the landscape that shapes gaming, right? And one of the things that's really fun is we're both technology policy experts. We're also gamers, right? My brother won an Odyssey in a school fair by dropping a coin into a big barrel of water that drifted down into a cup. And so and my uncle had an Atari, and we've been playing, and this is something that we've bonded over for many years. Luis is the reason my son is obsessed with Smash Brothers. He came over and we were playing together, and my son said to my wife, who's very pregnant at the time with my daughter, "Can I go down as a 2-year-old?" And she said, "Yeah, sure, you can join them." And ever since then, he wrapped himself up as Sheik, would run around making sound effects and things like that. So this is the bond that joins us. And the fun thing, the scary thing about working in this space is you get to recognize all the things that shape it, right?
Yep.
So with that, let me turn it back over to you.
Sure. So I'm going to show a quick video from 1992, but a lot of the things that are said there in that video are very topical today. But I'll just play it, and hopefully you guys can hear it. But if not, you'll get the gist of it.
For those who have not seen these so-called games before, I want to show you what we're talking about. What you're about to see are scenes from two of the most violent new video games. First, we have Mortal Kombat, which is a martial arts contest involving digitized characters. We're going to show two versions of the game. In the first segment, which is Sega's version, blood splatters from the contestants' heads. When a player wins, the so-called death sequence begins. The game narrator instructs the player to finish, and I quote, "finish his opponent." The player may then choose a method of murder, ranging from ripping a heart out to pulling off the head of the opponent with spinal cord attached. The second version, made by Nintendo, leaves out the blood and decapitation, but as you will see, it is still a violent game. For a lot of you to see, but there's blood splattering every time.
Kato wins. Flawless victor fatality.
Okay, so there was a lot there, but sort of the few things I want to point out and what matters for sort of tech policy and law is that, one, this was a hearing held in Congress about a fairly new technology. Home consoles had existed, but they weren't at this level of sophistication for the time. Former Senator Lieberman expressed concern for kids. What are politicians talking about today in Congress? Concern for kids. There was an explanation of what a video game was, and I'm sure he explained it in a way that would get his goals across, to try to get a law passed, to try to get more attention to this. And ultimately, there was a demonstration, there was a demo of the video game to indicate his point. So I'm going to pass it to Travis to talk about sort of the main idea of our panel, which he kind of touched on earlier.
I touched on a little bit, right? Video games, the games that you get to play, the games that are the way they are that way because people are creative, they want to play, and video games have been quite lucrative and make a lot of money, but they also are shaped by deliberate choices and balances that happen through politics, right? These are hard things that people grapple with and it goes through these like hard, complex policy processes, and sometimes these decisions end up in a good spot, and sometimes they really don't. And a lot of times these kind of decisions are happened in ways that are opaque and that are not visible, and that you might be affected by. And again, I mean, this is true of like all aspects of life, but just in terms of video games, right? Like which video games you can play, how you can play them, when you can play them. Like decisions have been made through law and policy that actually shape that. And so
one of the things that we want to say is that, right, these are shaped by policy choices, by law. We may not be aware of them, but sometimes we ask, like, why can't I have that thing in gaming, right? Yeah. And maybe that is a policy and legal choice, and maybe it's not always intended, but it just happens that way because some people sought to regulate a technology 30 years before we even knew what the internet was.
So in terms of how we're shaping our discussion, we're going to start off with a bit of privacy. We're going to have quite a bit of discussion about intellectual property, because that is the area where it's probably least visible in terms, or least scrutable in terms of how these policies function, but has a huge effect on gaming. We're going to talk some about other topics like competition, age verification, things like that. And then, we're really excited to engage with you all, answer questions. There's a lot of topics that we're probably not going to cover that we're happy to answer questions about. So we can, that's the overall.
Yeah, and even within this, like even within these topics, there's so much to cover that could be its own panel. Yeah. But before we do any of that, since we are focusing a little bit on the United States, I do want to mention the First Amendment, right? So most of us know it, right? Freedom of speech. But one thing that's relevant to video games, right, is that video game as an expression, as a medium to communicate, does qualify. There was a case some years back involving sort of regulation of video games, and the Supreme Court was very clear that it does count as speech. But I want to make that point because when we talk about speech, it's speech by whom and for whom, right? So it's speech by the developers, speech by the publishers, speech by the platforms that host content, but also speech by the players, right, and speech by the users. And part of the reason why I became interested in technology policy is because of this idea of communications being sort of protected, and who gets to talk is a very important concept. And that's going to permeate, I think, a lot of our discussion when we talk about sort of the choices that people make. So I'll move to privacy.
Yeah, so one thing that you'll kind of see throughout is I actually don't have as many slides, but I will do a decent amount of talking. So on privacy, privacy just as a baseline level, I like to think of everybody knows what privacy is on kind of an intuitive level, right? Like everybody knows that that there's some information that you don't want other people seeing. There's some communications that are for particular people and not for others. But at its core, privacy is the politics of information, right? It's an intuitive sense around the way in which information flows and is controlled, particularly about individuals and people. And some of that includes, like, whether or not that information, if it's given to an entity like a company, whether or not they actually keep it secure, right? And we have seen multiple instances of people who are playing video games have their information breached and used for fraudulent or criminal purposes. Probably the most famous one was the Sony breach, right? But we also see this information collected in video games being used in ways that are not necessarily understood by the people who are playing the games, who are purchasing the games and services, and being used for commercial purposes or other purposes. Virtual reality video games are super cool, right? They're so much fun. And Luis actually and I, pre-pandemic, got to go down to somewhere in Tyson's Corner, Virginia, and we had like a Ghostbusters-esque backpack that they put on with a VR helmet, and we got to fight Darth Vader. And it was great. The thing is about those types of tools and technologies is it tracks you intimately. And it has to do so, right? It tracks your eye movement. It tracks your body movement, right? All of that information and data is data that they collect and they can use, right? And so in terms of the laws that are currently govern the United States, there are a number of sectoral laws that govern privacy, but for the most part, we don't have an overarching sectoral law, such as the European Union does with the General Data Protection Regime, or GDPR, which some of you may have heard of. What we have is we have the Federal Trade Commission has what's called Section 5 authority that says that if you, that is against unfair and deceptive practices. And for the most part, what they do is they argue against deceptive practices, which means that if a company says something and it does something else, the FTC can sue them. The thing is how that translates into privacy is they say in their legal documents that everybody sees and very few people actually read, here's all the things that we are going to do with your data. And then you agree to it. They are not being deceptive, except when they are, even with that mealy mouse minimal nonsense, right? Like, companies are still deceptive. They still get caught by the FTC. They still get put under a consent decree, which means that the FTC can actually go in and watch them and make sure that they're not being, making things up. But all of the information, the thing is with gaming is that a lot of this information, again, like with VR, it's necessary for it to function. With MMOs, like you want a lot of that information in your player data and your history to be available and to be accessible on the cloud and have interoperable play, right? But a lot of that is made, like that is information that is then available, not, there's, again, this intuitive sense of privacy about like the people you want them to not have it, but it's still accessible to all of these companies and used in ways that are described in abstract legal terms that they can then argue, yeah, we're wink, wink, nod, nod, we're totally keeping this stuff safe, right? And so the collection of information is not necessarily bad, but the ways in which they're used and the fact that there are very little constraints about that usage is really concerning and does oftentimes lead to overcorrection and the inability to do interoperable play, right? Oftentimes that's actually to the company's benefit to make sure that they have their own like versions, and you have to replay the game all over again if you don't just simply upgrade on the next console, your console, but go to a different console. But that kind of interoperability is argued is impossible because of privacy concerns.
Yep. And then that leads us to sort of the different benefits and trade-offs to intellectual property, which is going to be the bulk of our discussion here. in many ways, intellectual property is a non-existent term. It is a bucket term for many things. The best way I would like to describe it is ways to protect products of human intellect, and I put human with a question mark because AI, right? Where people are trying to decipher to what extent, can an AI independently own something. There are a few things within intellectual property that people here have probably heard of. Copyright and patents and trademarks are sort of the bigger ones, and I'll go over a little bit of copyright and patents. But suffice to say, all of these essentially are ways to protect someone who uses their intellect to create a product and benefit them financially, benefit them with rights, so that they can use the product exclusively or license that product to someone else. But at the end of the day, that exclusion also means that people who may want to use it for purposes that the owner didn't intend themselves are not able to do so. This slide is actually from the U.S. Patent and Trademark Office, and I'll just read what it says. IP is all around you, and that's right. Even in this room right now, IP is like the ether. It's invisible. It's everywhere. There's that sculpture of a cat on the upper left corner. That's IP. It's, believe it or not, sculptures can be copyrighted. That plant, it's a plant design patent. Yes, plants can actually be patented in some instances. Trade secrets, if you happen to have the Coca-Cola recipe, congratulations, you have a trade secret, and therefore you have that IP protection. Photos, images, business methods in some instances. I'm not going to talk too much about trademarks, but essentially trademarks are source identifiers for products and services. In games, this is important because you want to know that your game is officially licensed by Nintendo or something along those lines. But beyond just the gaming consoles themselves, you'll notice that I put the M for mature rating, the ESRB, the Entertainment Software Rating Board, also has their own trademarks over their own logos. And in fact, not in the gaming context, but sort of in the movie and child teen using social media context, Instagram recently kind of came out with sort of their own rating systems, and they called it's just like the ratings you use at the movies, like rated R, rated PG-13. And the Motion Picture Association basically said, no, we never endorse that. Those are our ratings. Like, when people go there, they trust us because they know what we're doing.
And they don't trust Meta.
So I want to focus a little bit on patents and copyrights and the impact they've had on games and how we play those games and interact with those games. And I want to go back to sort of the Constitution, because this is one of the few things that is actually in writing that Congress is allowed to do, which is to basically grant patents and copyrights, which is fascinating. The way that Congress then decides to adopt laws to effectuate this clause, those are choices that we will talk about.
And him calling this exciting just shows that there's so many different versions of nerds, and it's all intersectional.
This could be a lot longer. So this is a short version. So probably, when it comes to patents in video games, it's a topic that's not discussed as often as copyright, but I would argue it's just as pervasive. Has anyone here heard of the Nemesis system? Okay, there we go. So I don't have to explain it that much. Yeah, the orcs in the game kind of learn, they become stronger, they become generals. If you take them down, they gain, you can help beat Sauron's army.
You can humiliate them so much that they go mad, and all they
Yes.
say is, ooh, 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 ooh.
But that Nemesis system is actually protected by a patent, and here's the patent, right? That's not all of the description. The description is like dozens of pages, but it kind of gives you a general idea. If you look at the abstract, there's very lawyerly language about what it does, what we just described and we know intuitively. And then there are some nice images that you can probably barely make out, but it sort of depicts the Nemesis system. But the thing is that essentially, people invented this system. It was granted as a patent, as an invention. Those people gave the patent, assigned it to Warner Brothers, and then Warner Brothers has had it since 2021. Patents like this one last about 20 years since the time of filing. The patent was filed in 2016, so the patent is viable until 2036. And what that means is that if you want to be able to use something like the Nemesis system, you have a couple of options. You can license it from Warner Brothers if they're willing to license to you. You can try to work around it and create something that says, hey, like this is sort of similar, but it's a different thing. It's not really the patent. And then you have to hope that Warner Brothers doesn't sue you. Or you could try to argue, the patent is invalid, right? There's some prior art, there's something in the past that says that this is very common, or this is the kind of stuff that should not be patentable. That takes a lot of money. So you may have heard that last year, Warner Brothers closed down Monolith Studios, which developed the Middle-earth Shadow of Mordor and Shadow of War series, and they were developing the Wonder Woman game. And so the way that this was reported is that basically the Nemesis system is just closed. I don't know that. I don't know what goes behind boardrooms and what decisions are made or not. As someone pointed out on X, on Twitter, it is controlled by WB, but they can license it. I have no idea why they haven't licensed it, but it does in fact, regardless of that decision, it does mean that that system is closed off until it is licensed or given to someone else or invalidated. There are a few more patents that I just think would be relevant, I think, to discuss briefly. So did anyone know that like PlayStation games were allowed to have sort of loading screen games, but only if you actually licensed a particular kind of patent? Yes, so there we go. So the most famous game that did this was actually Ridge Racer. And you could play Galaxian while the game loaded, and back then you had very long loading times, so it was particularly useful. And that patent finally expired 20 years after 1994. So there was a long time where we had games that had very long loading screens, where maybe something like this could have been done. But again, maybe, and I haven't researched too much into this, but maybe the patent should not have been granted, or maybe there were other implementations that would not have violated the patent, but those are choices to make about whether to litigate that and to have that claim. Maybe you just let the loading screen load, and you don't have that quirky minigame in the middle. More recently, this is something that happened last year, there was a patent granted involving summoning characters for Pokemon, and there's also Pal World involved, and that's currently sort of being debated right now. And then the one last thing I want to mention about patents is controllers. So controller design, controller inputs, a lot of that is actually patentable, like the D-pad, for example. Oops, well, I think we lost our screen. All right, well, I can just move on. What's up? There we go. We got the strike. There we go. All right, so this is what I want to talk the bulk about because it's probably the thing that people here know a lot about or hear about, and there's a lot that mystifies me to this day about it. So that's why I tried to study it for the last 10 years, and I still find that I'm very mystified about it. So patents protect inventions. They are essentially the closest thing you get to protecting ideas. That's why they last 20 years, which may still be a long time, but wait until you hear about copyright. With copyright, copyright protects expressions of those ideas, right? And it touches a lot of things, right? So movies, sound recordings, songs, sculptures, books, software, video games, and the like. It is a legal method to protect the author's original work of creative expression, but the courts have said that you only need what they call a modicum, very, very tiny amount of creativity. It doesn't include ideas, names, short phrases, but it basically includes everything else. It's very broadly construed, and once you have, it exists at the moment of creation, which means you don't actually have to go to the Copyright Office to register it, although there are benefits we'll talk about to doing that. But once you have a copyrighted work, you have the exclusive right to reproduce it, prepare a derivative work, which means making a book into a movie, distribute copies of the work, perform them publicly, display them publicly, and so on and so forth. So I want to take a little detour and talk about Oscar Wilde for a bit. So this picture was taken in the 1880s, and it was a major subject of a copyright dispute back in the day about whether photos could be copyrighted, because photos capture facts, and facts can't be copyrighted. But if you look at its expression, if you look at its pose, the photographer worked with Oscar Wilde to do that. And so the Supreme Court basically said, yes, the Constitution talks about protecting writings. Photography is a writing, broadly speaking, where there are choices, artistic choices that are made. Therefore, this gets copyright protection. Why does this matter for discussion about tech policy and law? The camera, player piano, photocopier, video sound recorders, personal computer, the internet, all of these have been challenges to the systems of the day of how people communicate. They're all mass copying and reproduction technologies, and they all provide challenges and opportunities. And our means to communicate and express ourselves are tools to create copyrighted works. So we often see this story in copyright land where you'll have a new technology pop up. People will say, this will ruin our industry, right? Player pianos will ruin the musician industry. Movie theaters will ruin plays, etc. And yes, sometimes there is, in fact, job displacement. But often you find that things just kind of coalesce, and some of the original industries that we're complaining about that end up being the ones using the technology. For example, there was a case in the 1980s involving video recorders with Sony and Betamax, with Sony and Universal. Basically, home recording was going to destroy movies, but the Supreme Court found that that was not copyright infringement, at least for use in your homes. And lo and behold, home recordings, Netflix is kind of the thing of the day now. But now let's pivot a little bit to video games, right? Back in the 1980s, Pac-Man came out in arcades, and Atari had the exclusive license to bring Pac-Man to home consoles. There was another company, North American Philips, that beat them to the punch. And they put out the game to your right, which is KC Munchkin. And so Atari sued and basically said, hey, this is just like a Pac-Man clone. And it didn't help that it was actually kind of advertised as a Pac-Man game, just putting it out there. There were other claims beyond copyright, but it really did not, the judges were not pleased. But this was one of the first cases to think about how copyright protection applied to video games and computer software more generally. This is an actual quote, which I'll read from the case. Based on an ocular comparison of the two works, we conclude that plaintiffs clearly showed likelihood of success. So the court just kind of looked at this and said, yeah, that looks right. And there's a lot, if you read the case, right, there's a lot of legalese and verbiage in it. But at bottom, what they basically said, hey, these kind of look the same, they kind of smell the same, they are basically the same. And so what happened is that North American Philips lost, Atari prevailed in this case, and it made it harder. Well, it basically not entirely outlawed, but it made it very difficult to kind of sell those copies of KC Munchkin, which, by the way, I have one here. So if you have an Odyssey 2, or I think there might be one in the museum. I tried to get in earlier to check, but they wanted to check in my laptop, so I didn't do it. But yeah, hit me up afterwards. We can go play it. All right, so the bottom line when it comes to copyright is that we are all copyright users. We're all copyright owners. This means we can all benefit, but we can kind of all infringe as well, even without knowing. You don't need intent to infringe. Intent matters for damages, but this is copyright in the U.S. It's what's known as a strict liability statute, which means you don't need to have a guilty mind. You just need to do the guilty act.
Which means that if you're putting together a PowerPoint presentation with your friend who cares a lot about this stuff and knows a lot about it, you have to be very careful about what images you put in.
Yes. Which, by the way, we will talk about this in a bit, and we'll come back to this slide. I'll talk about duration in a bit, but as I previewed, patents are, last about 20 years from the date of filing. Copyright lasts from life of the author plus 70 years, and I'll get to that in a bit. As I mentioned, copyright exists at the moment of existence, but there are many benefits to registering your copyright. Probably the big one that people are familiar if they've seen the FBI warning, like right before movies, is what are known as statutory damages, which means you don't actually have to show how much you lost. You just kind of go to the court and say, pay me anywhere between $600,000 and $150,000 per work infringed. So very quickly, if you think about what I mentioned about sort of the massive copying machines that we have with the internet and computers, that can accrue into the billions and billions of dollars and quickly ruin someone. I also want to talk about one other remedy that is not seldom talked about, which is called impoundment and destruction. So if you violate copyright and that violation is inseparable, then the court can order the physical destruction of your work. And this is actually what happened with Too Human. Has anyone ever heard of that game? Okay, there you go. So I put in sort of the law there, but it basically just says, yeah, this can be destroyed. And that's what happened with Too Human because there was a violation of, I believe, the Unreal Engine. All right, but let's go back to sort of life of the author plus 70 years. Back when Congress first passed the first Copyright Act, it used to be 14 years renewable once. So now it's gone up to 70, life of the author plus 70 years, 95 years if you are sort of an anonymous author, but we'll just focus on the life of the author plus 70. That's a lot, right? That's you, that's like 2 generations, maybe more after you. And what's interesting is that, the Constitution says that you need to have copyright and patents for limited times. And essentially, the way that this has sort of been interpreted is, well, life of the author plus 70 is kind of limited relative to the existence of the universe. So what that means is that something like Steamboat Willie, which first came out in 1928, wasn't really in what we call the public domain, meaning that you don't need permission to use it until January 1st, 2024. And I know that because on that date, I was at Disneyland celebrating Steamboat Willie going into the public domain. You can't really see it, but I'm holding like a copy of Steamboat Willie while Steamboat Willie's playing behind me on Main Street. But what this does, once something has been in the public domain, it kind of allows you to use it without fear of violating copyright. There are other things you have to be careful, right? So if you want to create your Mickey Mouse game, you have to really make sure that, 1, it is kind of based on the Steamboat Willie and not Mickey Mouse from later, and 2, that you are absolutely not saying that Disney's endorsing you, because that is a trademark violation, and that carries separate liability.
It also means that any video game, right, is currently covered.
Yes, any video game is currently covered, right? If we think of video games as beginning in the 1950s and 60s, they would be covered for many more decades. Yep. That's right, and it means you can't, unless there's a defense or an exception, which we'll talk about, you can't really iterate on them or work off them, even if the original copyright owner is no longer with us, or even if we don't know who the owners are, because sometimes they just put stuff out in the public and they never kind of attribute it. So just want to briefly mention that January 1st is sort of informally known as Public Domain Day, and in 2026, these are sort of the works that came out into the public domain. So if you do want to make your video game out of these characters, you can do it. Just be careful of other rights. So there are some limited exceptions, limitations to copyright where no permission is required, and this has been really foundational for video games. But to provide some background, the big one I want to talk about is fair use. There are a few others. For example, if there are only a few ways to express an idea, there's also the notion of first sale, that yes, copyright protects me if I were to, if I want to choose, if I had made Casey Munchkin and I want to sell a copy of it, but I can't sue Travis if Travis wants to sell a copy of Casey Munchkin to you. there's a very long discussion about games as software because courts have interpreted software as not being copies under the Copyright Act. Instead, they are sort of licenses or permissions, which is the reason why you can't just go into your Steam library or even when you download a game and just kind of sell it to someone or even give it away without potentially violating copyright. That is an entire panel, but that's basically the state of the law currently, and it prevents, for example, the secondhand marketplace, right? And then one last thing about memes and protecting memes. Sometimes courts do these things where they call it the de minimis doctrine, which is things are too trivial for us to care about. So maybe if you don't get fair use, which I'll talk about, maybe you can, try to get the de minimis in there. So fair use is probably the most well-known and least understood defense in copyright. It is a way that you can argue that the use that you're doing of a copyrighted work is not an infringement, even if you did not get permission. There are several factors: purpose and character, nature of the work, how much you use, how much commercial impact it has. But the bottom line question is, are you superseding the original, right? Are you just taking over and sort of invading that marketplace? There are a few things I want to say about fair use, and then I'll give you some examples of how this occurs in video games. One of them is, it's case by case, meaning that just because you see this happen in one instance doesn't mean it'll happen in another instance. You are on the defensive. If you are arguing for fair use, you may have already been sued, and there's a lot of money already involved. So it is not ideal. It's not an ideal position from the perspective of someone who might be sued to wholly rely on fair use, given the totality of damages that copyright offers. But sometimes you kind of have to do it because there's no other alternative. So in the context of video games, in the 90s and in the early 2000s, this actually came up in reverse engineering and emulation, and weirdly enough, screenshots for emulators. Basically, gaming companies had a sort of a monopoly over the console and what could be played on their consoles, and other companies tried to reverse engineer that software, find out what was useful or find out what about the code would allow them to create games that were not licensed, say by Sega, put the game in, and then not have to pay Sega a royalty, for example, to basically make a Sega game. The courts actually found that this was fair use. That eventually, like in the Sega Accolade case, for example, it involved the copying of a copyrighted computer program to understand unprotected functions. Accolade wanted to do this because they wanted to make the software compatible with Sega's consoles, and the court found that it was fair use. Now, in the Connectix case, I don't know if anyone has ever heard of the Connectix virtual game station, but it was basically one of the earlier emulators available to play on your PC, and you could play virtually any PlayStation game. And the same thing happened. The company that created Connectix, the virtual game station, had to copy part of the BIOS of the Sony PlayStation in order to understand how to create the emulator. And the court said this was fine, that even though Connectix wanted to create the emulator for a commercial purpose, that was a factor that was relevant, but it was not determinative. And the Bleem case is interesting because Bleem wasn't exactly sued after the Connectix case over the fact that it was copying code to create an emulator. It was actually sued because it was marketing its emulator by doing comparison shots between PlayStation games and games being played on the Bleem. And the court said, no, this is fair use. Like, people want to know the difference between, lower resolution, lower polygon count, PS games and the high quality Bleem games that you could play on PC or the Dreamcast.
That wasn't the hard mode.
That was not the hard mode. This is like pre-internet stuff. So a couple of things happened in the 1990s, and that was sort of the rise of the internet, and with it, the Digital Millennium Copyright Act Copyright Act, or the DMCA. So I think many of us have heard of DMCA. I got DMCA'd. I got DMCA 512. My stuff got taken down. But what does that actually mean? The DMCA was a law that was a response to newer technologies and online services. Something came along that began to make a lot of copies, and a lot of people had access to it, and Congress responded with this law. But these were policy and legal choices to further goals of the 1990s and how we saw technology and interaction back then. What should today's goals be is, I think, one question that we want to pose to you, particularly for the Q&A. Under the Copyright Act, under Section 512 of the DMCA, it creates what it's known as a notice and takedown system. Basically, it says, hey, if you are like a YouTube or you are like a Facebook and people use your service and they put up content, you, YouTube, Facebook, you will not be liable for copyright infringement if you remove access to the material. So you disable it, you notify the user, they can try to put it up, they can try to restore access, but it becomes a little bit of a mess, right? So the incentive that is created here for companies that are sort of the intermediaries, so that's sort of the between point between users and companies and other companies, is to remove content, because that basically allows them to not have any liability under copyright law. Companies could well fight this, like YouTube sometimes potentially fights it, Facebook can fight it, but that's a lot of money. It's not always clear whether a use is fair or not. So usually the best rational decision from a market perspective is just take down the content. But over time, that's very voluminous. It takes down a lot of content. Some of it, full versions of movies, fine. But other times it could be people using images of a movie or clips of a movie to comment on it, which is more commonly, characterized as fair use. But it's not the the online service's responsibility to monitor that, right? Their responsibility is to their shareholders, and their shareholders don't want those companies to be sued. Ergo, you just remove access to the material. You have 512. You have protection from copyright liability. You're all good. So I've talked a lot about sort of copyright, how it's everywhere, there's a lot of monetary damages, how it impacts some gaming. Talked about this idea of like stuff on the internet can lead to a lot of liability, so the incentive is to just kind of remove it. But I want to show you an example of what this means in a recent game. Has anyone played Life is Strange True Colors? Yeah. It's a really good game from the Life is Strange series. It's one of my favorites. But what I noticed when I went to the options menu is that it has a mute licensed music function. That's not in the law. Like, that's just a thing that they just created. And I don't know the developers. I don't know sort of their risk profile or like why they wanted to remove this. But it's a fairly safe bet that they probably were only able to get the license to use it in the game for a personal use, and that it would have cost more money if it was sort of more broadly broadcasted. And if people were to kind of stream the game, say on Twitch, by playing the licensed music, their accounts would be taken down, the company might be in trouble. So they had this licensing sort of streamer mode option available. So I'm going to play you a very short clip, which I hope it's not violating anything, because this is sort of educational panel, of what the game looks like with the sound on. A very short clip. Okay, that's it. So you're rocking out, okay? Now, what happens if you turn on streamer mode? It keeps going.
You haven't lost a beat.
Okay. So this is the short version. There's actually a longer video, right? But like, this is a choice. This is a deliberate choice to not include the licensed music because if you stream, it might get automatically taken down. The company might get sued, but it also significantly alters the player experience if you are a streamer of the game and want to share it. I mean, there's a lot of humor in it. I agree, it's hilarious. And maybe you can put public domain music over it, but it does, it is sort of like a conclusion of like the last 30 years of law and the choices that they have set up for everyone that, you know, has to deal with copyright. But that's not all. There's something more. There is something known as DMCA 1201. And, you know, I've talked a lot about the right side. This is everything that copyrights protects. But what if I told you that there's an additional law on top of that that basically says, hey, if you break locks, DRMs, TPMs, technological protection measures, to access these works, you're violating a separate provision of copyright law, regardless of whether or not you were making a fair use, for example, or some kind of other non-infringing use. So you could totally be try to make a fair use of something, but if that is protected by DRM and you break that DRM, you're separately violating another provision of copyright law. So now, as I previewed with Emulators Part 1, we're going to Emulators Part 2, which is, you know, I'm sure many people here have heard about Dolphin, the GameCube emulator. It's still kind of out there, and, you know, I certainly don't know sort of its legality, but there has been previous case law that suggests that a lot of, you know, emulation is fair use. But there's also this component of, well, if there is stuff that you need to access in order to make the emulator or to put it up that is itself copyright protected, and you break that lock, then you're violating 1201, regardless of whether the underlying use was actually a fair use. So now you have to take it down. Or you have to, you know, try to litigate it, and you probably, you know, suffer a lot of damages. What's interesting about this particular story where Nintendo sent sort of a cease and desist letter to Valve to not allow Dolphin on Steam is that some later reporting said that Valve actually tipped off Nintendo about this and essentially got the letter sent to them. Quote, Valve doesn't dispute this. Given Nintendo's history of taking action against some emulators, we brought this to their attention proactively after the Dolphin team announced it was coming soon to Steam. So again, that is a choice, right? Valve is explicitly saying, we did this because Nintendo is litigious. There might be a world where having a Dolphin emulator on Steam is okay. I don't know, but we never got to try.
Which also means that even if you're not violating copyright, they can put locks on things. And if you break those locks to use it for something that you can and should use, you have a legal right to use it for. You breaking that lock means you're violating the law.
Yes. So another way that this is also affecting games is with game preservation. So there are a lot of games, obviously games are protected by copyright, but sometimes a game is out of the marketplace, and sometimes it's in a physical medium that is deteriorating, like a CD or an old cartridge, and so you want to preserve it. You want to preserve it because you want to study it, you want to preserve it because you want to share it, you want to preserve it because you want to play it, right? What do you do with games? You play them. So one of the ways that this has come up in the context of this DMCA locking rule is copyright holders are arguing that when you essentially try to do this process, you are inherently breaking DRM, and that by breaking that DRM, you're violating 1201, even if it would be a fair use to make a single copy for research purposes inside a library that no one else can access. Now, in addition, because Congress realized that 1201 could be a little bit onerous. They did put in some permanent exemptions, which are limited, but they also put in a process where every 3 years you can go to the Copyright Office and basically try to get a temporary exemption. And you can say, hey, this is fair use. This doesn't like kill the market. Like this is really valuable. Please allow us to break the locks for the next 3 years until the next rulemaking comes. That is a very expensive process. And it requires very subtle technical expertise to actually do. And it has come up in the context of game preservation where there is an exemption now, but it's fairly limited to very old releases. It's limited to only being inside a particular institution for very particular purposes, right? With the concern that this would lead to massive online pirate arcades. Now, one reason I wanted to bring this up is because I have worked in this proceeding, but I'm only saying this in my personal capacity. Some years back when I was thinking about this question about when does an old game really kind of supplant like a re-release or vice versa? It's a very tough question because games are very different. Even re-releases are different, and people may want to study them for different purposes, right? Like you may actually want to study an old game because of the way that it played, the way that it functioned, the hitches that it had. Maybe the cleaner copy that was released 20 years after the fact doesn't have that. So this happened in the context of Nier games, where I basically made a very long point and a very long footnote that now most people have actually read. Prior to this panel, it was probably 7 people. That it basically says, look, like Nier came out quite a while ago, but actually some of the changes that the re-release made were very different than the original. So maybe you kind of want to study both. So that's also how sort of this idea of breaking locks to access works to make non-infringing uses comes about. And so now let's pass it on to talk about a few subjects that are also playing a role in games as well.
And I'm going to go a little bit faster just because I want to make sure that we have time for questions and conversation. But one of the big ones that's facing us right now is age verification, right? And I think everybody can agree that different content is appropriate for different people at different levels. And that it is okay and it is good to say that small children should not be playing or having access to adult content. However, what the response is, what you actually need to put in place for that to happen, are technical checks called, that's broadly referred to as age verification, and we're seeing this kind of play out. And this can be, as for most part, like up until fairly recently, this has consisted of, oh hey, we need you to put in your birth date, right? So you take out the calculator, figure out what 18 years was, you put that in and you're good to go, right? But what's starting to happen, and we're starting to see actual laws being passed, is that you actually do have to verify that you are of that particular age in order to gain access to that content, which sometimes can mean uploading government documents. It sometimes can mean biometric identification, either biometric identification of checking that you actually that government document is in fact you, or estimating what your age is. And those age estimations aren't great, right? And the big problem, there's a number of different problems with this. One, it is, to the conversation we had earlier, you're giving all that information to a company that says, trust us.
And one thing about that is that sometimes you're doing it when you're a kid. Over Christmas break, I was talking to my nephew, and he was explaining to us how he basically just gave all his biometrics and didn't need to ask his parents for permission in order to access a video game which shall remain unnamed, but is very popular among kids these days.
And that's the thing, right? And that's the thing, right? Is it's like these types of technological fixes actually undermine and undercut like actual parental conversations and discussion, right? Like one of the joys that I have being a gamer dad is that I get to play the games with my kids. And the thing that I actually care the most about is quality. We walk into arcades and I tell my son and my daughter, you can play all the games you want that are good. And we typically walk out. Right? Except for the old school penny arcade. We found one in Portland. We spent hours there. It was awesome. But that's my choice as a parent when they are small. Once they become teenagers, once they become actual adults who have the ability and the need to be able to explore, it becomes important that they are able to do that. And with examples such as Roblox or others, it's not just playing the games, it's access to those communities. And again, this is one of those problems of yes, we can all agree that just putting a 5-year-old online and saying go for it isn't probably a good idea. But a 15 or 16-year-old, forcing them to upload their biometrics or have tracked, like have active logs that are accessible by everyone, including their parents, of what they are saying in a game chat is much more concerning, right? And so again, this is where, like with copyright, the basic premise being that if you make something, maybe you should be allowed to make money off of it, right? That's kind of the basic premise that everybody can agree with. The idea, kids should be allowed to access communities and content that is appropriate to them for relative, in terms of their parents. Like, that's agreeable. But all these decisions and technologies that are then built on that are these additional policy choices that it's a very choose your own adventure kind of thing that ends us up in situations where people end up being more surveilled, do not have access to communities, and where things can be are very easily censored.
Yeah, and just one last thing about AI, right? Like AI obviously is pervasive and everywhere. And one thing to think about in the context of sort of age verification, where AI sometimes is being used and otherwise, is that there are a lot of issues involving it, including transparency, job displacement, when do we know something is or isn't AI? And we think it's very obvious to say AI is going to continue to be the big deal moving forward, not just in the way that games are created, but also the way the games are consumed and the experience we have around games, even with things like age verification. Yeah, so do you have any last words?
Well, I mean, we only have 5 minutes left, but I would love to, if anyone does have a question, would love to, I think we've got a bunch.
Please come to the mic.
If you don't mind coming up to the mic.
And we'll be here afterwards if you want to talk.
And we will absolutely be here afterwards to chat. Why don't you go ahead while people are still milling up?
So this is a two-parter question. With the advent of the deregulation of online sports betting and gambling, do you think that we will see developers potentially design two versions of games, one for EU, which has higher gambling protections, and one for North American markets to utilize heavier microtransactions like we saw with Apex, something like Apex Legends did with their Battle Pass?
Sure. So the question was, with the advent of online gambling and different levels of restrictions between the EU and the US, are we going to start seeing bifurcation and splitting of games? And I think that I don't know about gambling in particular, but we are seeing that.
Yeah.
I mean, think about the Chinese market, right? I don't know if anyone here is a Hearthstone player, but there's different cards, and Jaina's boobs gets covered, right? In the Chinese market, Marvel Snap, completely different game in China relative to the United States. So we're already seeing the same game in different markets, less so the EU and the US yet, but we're already seeing that happen.
And also, we kind of also saw it in way back when. Like I remember Half-Life. I think in Germany, like the enemies were robots that spewed oil.
Yeah.
So
Yeah. The other thing was with 512 requirements being rumbled about potentially on social media. Do you think there's going to be a wider use of AI moderation that we're seeing with YouTube right now?
yes, absolutely. Yes, that is already happening. One thing we didn't talk about that much is that AI. There is a lot of definitions to it, but machine learning has been a thing for a very long time. Companies are actively using artificial intelligence to moderate, and they're actively thinking of ways to even use generative AI on top of that to moderate. So yes.
Sure. All right. Thank you.
Thank
Have
you.
Hello.
Hi.
I was thinking about this. So we know that LLM training data sets are filled with copyrighted content that is stolen. Is there a world, because there was a mention of the de minimis, is there a world in which there is a de maximis and that so much has been stolen the court says, whatever?
That's a good question. I mean, what I would say is that when you read cases right now where courts are kind of opining on the use of AI, you see that judges are not very happy about the way that it's being used and the way that things are going and trained, and that may sort of affect their perspective on things.
I would just simply say that's more of a political question
Yeah.
than an actual legal question. I think at the
Yeah.
end of the day, there is like a little bit of too big to fail that might be ingrained in that. And I do think that like companies having to disgorge or destroy the algorithms that are based on copyrighted works would destroy all of them at this point in time, right? And I think that there's too much invested for that to necessarily happen. We might see payouts, like we've seen with Anthropic, but yeah.
Yeah.
All right, we unfortunately do need to wrap it up. Thank you, everyone.
We'll be here.
Thanks for the first questions. Really appreciate it.